We have breaking news. The Minnesota Supreme Court has officially dismissed the lawsuit seeking to ban Donald Trump from the 2024 Minnesota primary ballot under Section 3 of the 14th Amendment, which bans anyone from holding office who engaged in insurrection after taking an oath to defend the Constitution. Trump certainly qualifies, but the Minnesota Supreme Court decided they didn't want to go down that road. The Minnesota suit was the first in a string of such suits brought by groups looking to stop Trump from running based on his role in inciting the U.S. Capitol attack on January 6, 2021, and trying to stop the certification of Joe Biden's victory in what amounted to a coup attempt. Trump's attorneys said the court doesn't have the power to remove Trump from the ballot based on the 14th Amendment, and that Congress would first have to lay out some kind of criteria and procedures, which is not what the law says at all. In case that didn't work, they also claimed that Section 3 doesn't even apply to the office of president. Trump also claimed that he never took an oath to support the Constitution. Just as a reminder, let's look at Section 3 of the 14th Amendment and see what it says about Congress. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So the mention of Congress is in regards to Congress, by a vote of 2/3 of its members, being able to override Section 3 and enable someone who engaged in insurrection to be able to hold office, i.e., remove that disability. As for the decision, the Minnesota Supreme Court said that this decision to dismiss the case only applies to the primary election, and that there was no reason that a suit couldn't be brought to remove Trump from the general election ballot should he win the nomination.